Welcome, dear Judicial Service aspirants. Today we are going to expose ourselves to one another aspect. It is that one shall have realistic visit of judicial discretion, human factor, justice, injustice, and our systemic limitations. This is an aspect with respect to which you will be ultimately at the center, and your index of functional reality is ultimately going to be adjudged in terms of these features of exercise of judicial discretion, you as a human factor responsible for justice, injustice within our system of limitations. It is practical, experience-based wisdom on the basis of which, and in the light of practical, realistic experience domain, it is suggested that you shall have a choice of one judge for being through his entire range of judgments. The one judgment which I am taking up is RSA number 579 of 1988 of Punjab and Haryana High Court. It is titled State of Punjab, etc. versus Shrimati Ratni Devi. The judgment is authored by Honorable Mr. Justice S.D. Anand. This judgment brings to focus as to how justice done or denied at the initial foundational level of subject is ultimately going to delay the practical fruit of litigations. This is the case of a cause of disbursement of the medical bills to an employee. This suit, simple suit for this relief, was dismissed by the trial court. The first appellate court reversed the judgment of the trial court, and the RSA was instituted in 1988. The same is decided in 2010, and 29 years thereafter, the initial cause of disbursement of the medical bills stood adjudicated. It is 29 years delay which is of a concern, and it also is an index as to how the small cause which stood dismissed at the initial stage has taken 29 years for effective relief. This small judgment deserves to be chewed. One shall be through this judgment and imbibe, firstly, the justice injustice in its practical terms, what it really means, and as to how one particular cause of such a nature as well has to wait as long as 29 years timeline. The conclusion in terms of this judgment is being expressed as that in view of the proven position that disbursement of the reimbursement charges had been denied to the respondent plaintiff widow for a period as long as 29 years, she shall be entitled to interest at the rate of 6% per annum on the amount aforementioned. The reimbursement charges shall be disbursed within 1 month from today. The order is effective, order is equitable, but at the same time, it really brings to focus as to how the state of Punjab had invoked the jurisdiction of the High Court as regular second appeal with respect to such a cause, and that too in the light of the judgment of the First Appellate Court. Let us be through this judgment. This judgment, let us read it. The respondent plaintiff filed a medical reimbursement claim in respect of hospitalization of her late husband at PGI. He was in employment of Education Department Punjab. The reimbursement plea was declined by DPI Punjab. The suit was dismissed by London Trial Court, which did otherwise advise the government to sympathetically consider relaxation of rule in favor of plaintiff respondent as a special case. In appeal, the finding was reversed by the learned First Appellate Court by order dated 23rd October 1987. The state of Punjab is in appeal against it. The essential premise for negativating the claim of medical reimbursement was that the patient was not forwarded by CMO concerned to the PGI. This is what weighed with the DPI. The learned trial court affirmed that view. However, the learned First Appellate Court obtained a different view by recording instructions related finding to the effect that government employees posted at Chandigarh, Rohtak, Patiala, and Amritsar were allowed to approach the medical superintendent of the specialist institution directly without prior approval of the CMO Director, Health Services. Relevant instructions dated 23rd, 24th March 1965 are available on record as Exhibit D1. The relevant part of the instructions is extracted here for the facility of reference. The government employees stationed at Chandigarh, Rohtak, Patiala, and Amritsar would be allowed to approach the medical superintendent of specialist institution direct without a prior approval of the Chief Medical Officer, Director, Health Services. The concession will be available to outdoor as well as indoor patients. The learned State Council argues that forwarding of the employees requiring medical treatment through CMO is appropriate because it puts the department in the know of the requirement of the employees on establishment. I have not been able to persuade myself to find any force in this plea. The consideration of request of the indicated category for the medical reimbursement must be relatable to the instructions issued by the competent authority. In this case, the instructions have been placed on record as Exhibit D1. Learned First Appellate Court noticed in the course of para 7 of the judgment facts which invite the applicability of instructions aforementioned to the deceased husband of the plaintiff respondent. Learned State Council is not in a position to aver that there is any factual inaccuracy in the facts-based observations made by the learned First Appellate Court in the course thereof. Even otherwise, the instructions issued by any competent authority in case of indicate category must not wish away the aspect of urgency-related compassion. If an employee has a problem which merits attention at a specialist institution forthwith, it would be impractical and illogical to expect that the employee or the person attending upon him would first undergo the ordeal of making a plea to the CMO or the DPI. It is time we shall start appreciating instructions of the award category in proper perspective. Let me reinforce this observation, this decision, this adjudication. It is time we start appreciating instructions of the award category in proper perspective. Ours is a public welfare state. Health-related welfare of the employee must be foremost in the mind of the employer. There is no substantial question of law involved in this regular second appeal at the hands of the state. An appeal is even otherwise denied of merit, denuded of merit. The appeal shall stand negativated accordingly. In view of this proven position, the disbursement of the reimbursement charges has been denied to the respondent plaintiff widow for a period as long as 29 years. She shall be entitled to interest at the rate of 6% per annum on the amount aforementioned. The reimbursement charges shall be disbursed within 1 month from today. Let us sit comfortably. Let us reflect whether this justice should have been allowed or not at the initial stage by the trial court. The second point upon which we must meditate and reflect is whether it was advisable at all for the state of Punjab to go in second regular appeal. And finally, we shall reflect as to how the system works, what are the systemal limitations, how the judicial discretion is to be applied, and this judgment also brings to focus as to the perspective in the light of which the instructions deserves to be interpreted by the courts. Let us read all the judgments of Justice S.D. Anand. We will be benefited. Likewise, it is advisable that one shall be through the judgments of at least one judge. Third, 3 to 4 decades experience, wisdom based judgments of a judge will be available to the judicial service aspirant. One can mature oneself, one can acquire the art of writing judgment, one shall be enlarging one's perspective. Here on the website of the High Court, there is a list of the judges at present in office in Punjab and Haryana High Court. Also, we are having on the website the complete list of all judges of Punjab and Haryana High Court since the day of independence. There is a very big reservoir of judicial pronouncements. Let us be through them. Let us mature ourselves. Let us make ourselves parallel with the expectations of justice. The goddess of justice expects from each one of us to be true to oneself and let justice prevail. Thank you very much.